right, welcome in. So we do have special guest Bob Motta, criminal defense attorney and host of the podcast Defense Diaries. So make sure you go check him out. The link is in the description. Um, Thanks for being with us, Bob.
Thanks for having me, Sleuth. I'm happy to be here. Happy to be here. What's been going on? What's good?
Not much. Hopefully, this is okay with you. I'd like to ask you, kind of start with asking you just a few yes or no, true or false questions. Give
Okay.
you my prediction of what I think, my uneducated prediction of what's going to happen here next with the Delphi case against Richard Allen. Give you that prediction, and then you can tell me how close I am to it, and then I'll just kind of let you off the leash here, if that's okay with you.
Hey man, it's your show, brother.
All right, I appreciate it. And once again, thank you so much for joining me today.
My pleasure. My pleasure.
All right, so let me know if this is correct. At some point before the trial, the prosecution must announce its intention to seek the death penalty. Is that true?
True. True. They
Okay.
have to give what they call its notice of intent to seek the death penalty. So they've got to do that by statute. And when it emailed me, I'll give you a little bit longer of an answer. When you
Sure.
emailed me last night, because in Illinois, you've got to do it early. Like you can't, like this isn't something where like in the middle of trial, McClellan can be like, oh, by the way, we're going for the death penalty, because with capital cases, there's just different rules. There's different rules about the types of attorneys that you have. They have to be death penalty certified if your guy's indigent. And that's where it gets weird with Allen's case, because he is indigent in the sense that Judge Gull appointed Rosie and Baldwin, who are private attorneys, but as we all know, they're getting paid because they're technically public defenders for him. Does that make sense? So, like, say for instance, if you were arrested and you're like for a horrific crime like this, and the
And
state's
I'm
like, all right,
homeless.
well, yeah, we're going to start the death, we're going to seek the death penalty. And if you're indigent, those attorneys, the public defenders have to be death penalty certified, or at least lead counsel does. Opposing counsel also has to be, or co-counsel has to be, but not quite to the same level as lead counsel. Lead counsel has to have experience with death penalty cases, has to have a certain amount of trials under their belt that they've taken to jury. Whereas if you have the money to hire private counsel, that's not the case. I mean, you could hire a probate lawyer. I mean, you'd be a fool to do it, but you can do it. You could hire any lawyer you want if you've got the money to pay for it. Like the court's not going to intercede and say, well, you're making a terrible mistake. You need to get somebody who's qualified to handle this type of case. So with Allen's case, just because of the fact that Carroll County is so small that they don't really have like a traditional public defender's office, like Cook County, where the city of Chicago resides, they have a huge, huge public defender's office. Like everybody that needs a public defender, there's hundreds of them in there. So, the court appoints a PD, and whoever works in that room, whatever courtroom it's in, that becomes
So
their
it sounds
case.
like
So
you're
here
about
it's
to
a little
answer my
different.
second question, which is, can Richard Allen face the death penalty?
I think it's too late in the game. But that being said, I mean, like Judge Gull doesn't always like follow the rules. I mean, Judge Gull, look, it's her case, and it's
I mean,
technically.
hypothetically, could he?
I don't know that they'd be able to do it at this late hour. Like I think because the things that exist, meaning like McClellan had the aggravating factor that he needed from the get. Like
And they need one of 16, right?
yeah, if kidnapping was involved, and as we all know, initially when they filed the charges, like kidnapping was one of the primary things that they're saying that Allen had done, because they were going under the felony murder theory, which is essentially at that point in time, they didn't have to prove that Allen actually killed the girls. They just had to prove that Allen kidnapped the girls. And as a result of him kidnapping the girls
died.
ended up dead. So, but when he, after the Supreme Court thing, like that day, I think is when he filed the amended charges, and he added, kind of straight up murder in there. So I think it's too late, man. I really do, just because, and like after you emailed me, I was trying to pull up some, because like the general rule is pretty vague. Like I'm sure you pulled it up. So if you
Yeah,
look at it, Indiana Code, like Title
I think I have
35,
it.
yeah, it's just that Section 9A. It says the state may seek either a death sentence or a sentence of life imprisonment without parole for murder by alleging, on a page separate from the rest of the charging instrument, the existence of at least one of the aggravating circumstances. So, and as we just talked about, kidnapping definitely is on there. So in theory, but they don't really, like when you're reading through it, they don't give you a time frame, right? So like when you're reading it, you're probably like, well, shit, like they could do this whenever. I don't see any prohibition or any kind of time frame and when they have to give the notice. So when I kind of dug in, I went into Rule 6.1 uh, in the Indiana courts and Indiana Gov. Courts, and that's for capital cases. All right, and so I was kind of trying to put these two things together in order to try to come up with like the definitive time frame, and the way that they put it there. And if you want to pull it up, Sleuth, it's uh in.gov/courts/rules.
Well, you can share it. You can request to share it if you want to.
Oh, can I put it up?
Yeah,
All right.
just go
All right.
ahead and put present, and then I'll give
Yeah,
you
I
permission.
use StreamYard too. I'll throw it up. Cool. Let's see. All right, because I think this is pretty instructive. I'll blow it up so we can see it. All right. Okay. Can you all see that a little better?
Yeah, that looks pretty good.
All right. So under capital cases, this gives us a little more guidance. So it's obviously whenever a prosecuting attorney seeks the death penalty by filing a request pursuant to Indiana Code 3552-9, the prosecuting attorney must file that request with the trial court and with the Supreme Court Services, Indiana Supreme Court, State House, blah 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 blah. And it must open a case number in the Supreme Court and notify counsel. All right, so the notice is for real. Like that's like a real thing. Like the it's not just that you're letting Gull know. Like you got to file it with the Indiana Supreme Court. Like capital cases are a whole different beast. Okay, so and then at that point, and this is what I was talking about with Allen. Upon a finding of indigence, which they found with Allen, we all know his famous letter. I'm gonna hire a lawyer.
I'm at the
And then,
mercy.
yeah, I'm at your
I'm at the
mercy.
mercy.
Give me a lawyer. And so then he says, it says, upon a finding of indigence, it is the duty of the judge presiding in a capital case to enter a written order specifically naming 2 qualified attorneys to represent an individual in a trial proceeding where death sentence is sought.
We
The
only have one, right?
Yeah, but like I don't know if either of them are. I think Baldwin's certified. I think.
What I heard.
I think that he is, but I'm not 100% on that. I heard that too. But I'm not 100 on that, because again, like if they're private counsel, like typically it's PDs that go get death, who are death certified. You know what I mean? Like Allie and I handled a death penalty case in Omaha, but we weren't death penalty certified, but we were private counsel. You know what I mean? So it was
Yeah,
like,
so that means the state, they're not worried about it because they're not involved in all of that. Their
well,
hands not on the scale at that point.
right, exactly. So exactly, I mean, and it's really that Sixth Amendment right to be able to hire the counsel of your choice. I mean, if you've got the dough, and the state's not coughing up the money, to hire the lawyers, then it's your thing. It's completely your constitutional right to pick whatever private counsel you want. Like there's no prohibition against it. But if the state's paying for it, they got rules. So I don't know, man. Like this thing, and then it goes through the lead counsel qualifications here,
And
and
this
it
is all
tells you
specific to Indiana.
this is the Indiana.gov. This is their website. All right, because that's why I was saying, I'm like, you could see right here they reference the code that we were looking at. So that's 3552-9, where we were looking at just which was this thing.
The murder
So
with the aggravating factors
right. So, which gave you no guidance in terms of,
or
well, how
timing,
late in
really.
the game? Yeah, how late in the game can they do it? Um, but you can see there's just a ton of stuff that has to be looked at, when the judge is appointing, and because he didn't give any kind of notice early, I don't think he's gonna pivot. I really don't. Like at this point, I mean, could he try? I suppose so. Whether or not it would pass muster, I don't think that it would. I think it's too late in the game, because he's had at this point going on 2 years, to do it, and he didn't do it because nothing changed in
Right.
terms of the fact pattern. It's like his confidence level may have gone up because of the amount of confessions, but in terms of like the facts of the case, in terms of what they were alleging that he's done with that aggravating factor, it's been that way. So I don't think that they'll change it. And really, when you kind of analyze cases in death penalty cases where you look at a prosecutor's office, where sometimes you're scratching your head and you're like, man, like I'm wonder why they didn't seek the death penalty on this case. It is harder sometimes to get a conviction on a death penalty case because
The
you do
pressure
the
on the
best.
jury.
It is. It's huge, man. I mean, you do the best that you can to try to weed out issues and voir dire when you're questioning the jurors, because they'll have specific death penalty type questions asked, and the judge will really dig into that too as well. So, I mean, a lot of times prosecuting officers will be like, you know what, on this one, we're just gonna have them go in on a life without the possibility because we don't want to risk it. And if he was at all concerned about his case early on in terms of just the amount of evidence that he had, then I'm sure it was a conversation that was taking place. And early on, Nick was flying solo pretty much. I mean, he had not much help in that office in terms of being able to bounce ideas off of. Now, obviously, he's got Diener as well, so he's got three brains in there trying to work it. But I'd be surprised if they did, to be honest with you. I just don't see the pivot. I just think that there's too many hurdles for them to clear. Starting with whether or not we already know what Gull's opinion is of Baldwin and Rosie, right? I mean,
Yeah.
I don't think that. I mean, she's got them on, but it's against her will. She still thinks they're incompetent, and all the other things that she's listed them as. So, like, that would seem to kind of fly in the face of what's required for counsel for an indigent guy. You know what I'm saying? I mean, in terms of the experience, they're good. They both
So
have
would you
20
be
plus years.
surprised if that somehow the death penalty popped up out of
I
nowhere?
I would be shocked. I would
Okay.
I'd go beyond surprise. I'd be shocked just
Even
because
with
it's
everything that's happened?
yeah, I
Okay.
think it's so late in the game, man. And McClellan would have talked to the families about it already. Like, that was a discussion. Like, they're not going to talk about the facts of the case that much with the families, but in terms of kind of what they're seeking, because typically you just like in Illinois, it's very, very early in the game. Like, you have to give your notice of intent that you're seeking the death penalty because it changes everything. It changes the amount of money that you'll get for experts because they just take it
Like
more
another
seriously.
$1,000,000, right?
Yeah, exactly. So and like we're what a month out, a month and some change out from trial. It would stun me. It would stun me.
Okay, well, here's my prediction. You tell me how close I am. It looks like the only fear that the prosecution really has is kind of worrying about retrying this case over and over. Do you think that they will give a deal to Richard Allen on based on the fact that he'll waive his right
So
uh,
that's it. That
to
was
appeal
an
the case?
interesting. I know you've been big on the plea thing, like in much to the surprise of everybody. Like I'm not in like that with the defense attorneys. I've certainly had conversations with them. I have not heard anything about a plea deal. And to be honest with you, the fact that the rulings that she made with the third party culprit stuff really it makes it much more unlikely that they'll take a plea deal, because if you talk to any attorneys that handle trial work, right, that do like a ton of trial work, whether it's Indiana or anywhere else, like her ruling on barring like basically any defense, and it's not just the third party culprit thing, I've been big on them moving off of that forever in terms of just strategically, because that's what I do. People are all thinking I'm on the like Richard Allen is innocent train. That's not my train. My train is every defendant in this country has constitutional rights to a fair trial, and I had some serious concerns for a really long time, and still do, about whether or not his constitutional rights were violated during this thing. And it really started with when she removed his counsel. So like I don't talk about innocence and guilt. I don't know the evidence. You know what I mean? I know what the rest of us know, and I hear the same rumors and stuff that everybody else hears in my DMs, as you could imagine. So I'm
Oh
sure
yeah.
you do. I've got people telling me all kinds of stuff, man, like all kinds of theories with, but I don't really talk about the facts because I'm a trial lawyer, and I'm glad that you had me on so that I could explain this, because people have a tendency to kind of listen to what other people say about me, not having ever listened to my content, and my
Exactly.
content really kind of speaks for itself, and I stand by everything I say. I have no idea if Richard Allen's innocent or guilty. I can tell you this: when we start hearing those confessions, that's going to tell us a whole hell of a lot, and it's like, my thing with the confessions is, look, I don't think anybody can argue that his mental state was in a really bad place during the time that these things took place. And it seems as if there were a bulk of them that occurred in that period of time when he was really kind of like, just, it seemed to be pretty psychotic.
Hmm.
But that being said, if there's details, that's a huge problem for Allen, right? I mean, if he knows things that only the killer would know, that's devastating for the defense to try to get over that. I mean, I'm certain that they would try to make the argument, okay, well, I mean, this isn't as if he gave these confessions while he was, being interrogated just after the arrest, and he gave details then. The timing of it's different. Like, he had obviously the opportunity to hear from his lawyers, because initially they had said, I think that the state's theory before, the one cop, I forget what his name is, something like Rushman. He was the cop that came on that listened to all the audio from all the calls that testified. I can't remember what his name, like Brushman or Crushman or
Yeah, not
Brushman.
sure.
Somebody will know in the chat. But he was the cop that they put on during the 3 days of hearings. Who's like, look, this I've listened to hundreds of hours of Allen on phone calls, and then like I started picking out everything that we considered to be some kind of admission. And prior to him doing that, if you remember, I think it was at the safekeeping hearing initially, the original one back in June, that's when it had come out with the first confessions. And then they were talking about the fact that after his lawyers had delivered him the papers, which I'm assuming was some form of discovery, that he started eating the papers, and that's when he confessed. So that everybody was on that. Now they've changed the story after they've had somebody listen to all the calls to this March 21st date, which is significant in the state's mind because that's the date that Allen found God, right? And then that he's like, all right, like, I gotta atone for my sins. I gotta talk to my family. I gotta let them know what's what. So, I mean, the state's theory has changed, but in terms of, I mean, they're coming in. They're all coming in. They're like the good, the bad, and the ugly. Whether it's one where he's saying, I shot the girls, which we know is inaccurate in terms of cause of death, and ones that may
And
be
feigning does
accurate.
exist, right? Like with that kind of stuff. People
Yeah.
like acting like they're confessing, but really they're giving false information, even though they are guilty.
Yeah,
A lot of weird stuff I'm
I
seeing.
mean, that's the other thing. Like when you think about a psychotic state, and I've had this discussion with Allison on lives before. Like I don't think the presupposition needs to be that the person's making things up. right? I mean, they could be psychotic and telling the truth. You don't know.
But it
You
could
know
be
what I
both,
mean?
right? It could be both.
It could be all of it, right?
Yeah,
You know, I
exactly.
mean, in terms of, so you know, I mean, we just have to wait and hear what was actually said and hear these things for ourselves, and you know, we'll judge it
I
from
agree.
there. I mean, ultimately, I think, and I know where your position is with, you know, this, the respect, the he was on the bridge. In your mind, he's bridge guy, and bridge guy is the guy, you know, and
Now
like
for
from
me,
my,
it's the timeline, and, I look at that, tool mark evidence as being very strong.
yeah, see, from my perspective, in terms of, I mean, even traditional, what they used to call ballistics, which they now call tool markings, that's spurious. Like in courts, like it's being challenged heavily. You know, like that field is really trying to improve the technology that they have, in terms of being able to really come, because it's like it hasn't fallen to the wayside like bite mark comparisons or hair comparisons, like what they used to use in the early days. You know, like before the science evolved,
How
they
much do
would
you
they
trust this expert?
well, that's it. And you know, and Indiana has a much lower bar. Like a lot of states follow either the Fry or Daubert. You know, those are the two ways that you challenge scientific evidence to see whether or not you know, it would be helpful to a juror and whether it's reliable science. You know, because that's how you're trying to weed out junk science. That's why you always hear about Daubert hearings. That's what it typically is. And Indiana doesn't really follow either. Like for them, it's more of an issue of weight than admissibility, meaning that like they're going to be inclined to let it in, and the judge will give an instruction that you give it whatever weight you deem appropriate, talking to the jury, as opposed to saying it's not admissible. So just like, I mean, if you kind of do research on, because I was on court TV or with Mike King one night, and it was like, it happened to be during Crime Con, and like we were on with Politan, and Vinny had asked Mike. He's like, Mike, he's like, the unspent casing. He's like, on a scale of 1 to 10, how powerful is that evidence? And Mike was like, it's like,
It's a good
Vinny,
question.
yeah. He's like, Vinny, that is a 10. That is off the charts power. So like, and I just had known from like challenging cases, you know, in courts, that it's not that. And if you look specifically, not for you know, bullets that have cycled through or projectiles that have cycled through the barrel, you know, because back in the old days, man, when all guns were handcrafted, you'd get the defects. It really was more
Yeah, it
like
was like a
like a
fingerprint.
fingerprint. It was, man, because every single one was handcrafted. They're all going to have different little nooks and crannies in there and defects. So there was, now they're all machine cast, and it's like you're gonna have to have a weird defect in order to be able to differentiate from one, you know, from one Smith and Wesson to another. And when you're talking about something being ejected out, um, I mean, we'll see who they're going to put on. I mean, that will be one of
The
the most,
jury
but
too, right? Plays a big part.
it's huge. That's the bigger part, and that's what I keep trying to tell people in my chat. And I'm like, look, the fact that it exists at all as evidence in the trial is huge for the state. It's like, because a lot of times when you put experts on and they X each other out, and the jurors' eyes gloss over, and they're like, they got two guys saying, you know, both sides are like, well, your guy's a hired gun, your guy's a hired gun. They're both hired guns. They're both going to say what you need them to say. The jury's like, all right, well, I'm going to X both those experts out, and I'm just going to go with what my common sense is telling me, and they're going to go with what their eyes told them. And it can be incredibly powerful evidence, even though, like, if you look at cases tried around the country, that an unspent ejected casing has never been the primary piece of evidence to get
It's
somebody
just like
convicted.
supporting, right? Kind of like in
Right.
the Murdoch case.
Exactly. So it'll be interesting. I mean, like that's going to be one of the more I think highly litigated issues in the case. And then with in sleuth, I haven't forgotten your initial question. I know I've gone astray. But like with
Yeah, and we'll get
respect
to
to,
questions after we kind of clear that
yeah,
up.
if anybody has questions or
Oh, they
comments
do.
or
They're
anything, but
coming
yeah,
in.
cool. You know, but the other thing that I was really, you know, I like on my channel, I've been really big on kind of like, in my opinion, if Alice and I were handling the case, I would not be leaning into the third party culprit thing like that, like not like they were, you know, and I get the sense that Baldwin is big on that, and Rosie is much bigger on
Think they have a plan B?
attacking. Well, I think the plan B is that like Rosie's strategy in terms of attacking the evidence that they have
Chain of
and
custody and stuff
focusing
like
on
that?
that. Well, yeah, but in like getting an expert to deal with the confessions, to deal with the bad evidence. Whereas Andy Baldwin seems to be really obsessed with just trying to point the finger at somebody else. And I think that the hope initially was to have a combination of both, to be able to attack the evidence and then say, all right, well, what about these dudes? You know, and then now we know that this trial is going to turn out to be a very lengthy offer of proof because the defense has to get it in. So the jury is going to be excused from the room, and we're going to see Baldwin for the third time. We've already seen him do it twice in terms of giving offers of proof on the third party culprit stuff. So it's going to come in, but it's not going to be in the presence of the jury because they have to make the record. Like if they don't bring it up during the trial, the jury is going to be pissed as hell. The jury is going to have to go out of the room, and it's going to take hours and hours and hours. And they're going to be like, "What is going on? Like what? Like why aren't we in there?" And so that's going to be going on all throughout the course of the trial. So anytime that they want to try to bring it up on cross examination, because if you look at you know what they did in the Karen Reed case, and I've always said that those two cases created the most toxic online communities because they had the one thing in common, and that was that in both of those cases, the defense prior to trial came out with their entire full theory of defense, which you just typically don't see. Because frankly, hiding what our theory is, which we do not have to you know, give that information to the state prior to trial. Of course, we have to you know, tender discovery. It's reciprocal. But in terms of what our theory of defense is, we don't have to provide that. Obviously, if you have an alibi, you have to give notice. If you have an affirmative defense, you have to give notice. But if you've got like a different theory, you don't have to fully lay it out like both of those sets of attorneys did. Like you saw it in both cases where they just had these filings that were like, here's the whole thing, you know, and this one you've got the Odin thing where everybody's like, either that's the most insane thing, you know, satanic panic all over again, it's
Yeah.
garbage. And over
West
there,
Memphis 3.
yeah, and then on Reed, you had the, you know, just the whole, now we've got, you know, 15, 20 cops that all conspired to, you know, take this woman down. So it's like you had both sides are like, okay, well, I buy that, I don't buy that. And for me, I'm like, man, like on both cases, I'm like, I would have taken a huge step back if I were handling the cases and just worked with the evidence that I had. You know, and here to challenge your concept of the timeline, that's where my biggest thing has always been with this case. It's like if the timeline is correct, okay, meaning that they can prove that the girls met their demise, which they have now set in stone between 2:30 and 3:30, then the defense has a real serious problem because as we know, Allen put himself there. Allen, you know, made that.
Yeah, no alibis from what I've heard as well.
I mean, he put himself on the bridge. We know he's there sometime, and I'm assuming like the fact that none of us know what's going on with Allen's phone, like there has to be info. Like no one's heard anything about Allen's phone. It drives me nuts. I'm like, what? Like, why haven't we heard anything about Allen's phone? Why haven't we heard about them doing, you know, the newest Cellubrite extraction version on Allen? Like, I've never heard anything about Allen's phones, and we know they collected a ton of them, like old stuff, probably flip phones. So, like that has to come out. So they're going to be able to place them here. But my thing and what came out during the 3 days of hearings is that, at least according to the defense, that no body temps were taken of the girls and no time of death has been established. That's a problem for the state. Like if as a defense attorney, I'm just telling you, that's what I'm focusing on. I'm like, okay, everybody's just assuming that the girls right after their thought to have been kidnapped, that's when everything takes place, like in a very short time frame.
But isn't that the crime that they're charging him with, is just the kidnapping that led to the death?
Well, no, now they're charging him with more. Now that doesn't mean that they have to find him guilty on everything. You know what I'm saying?
But do you think they can prove with that video that he did in fact kidnap them right at the 213 mark? Do you think that's going to be solid?
I don't know. I don't know. I'm assuming at some point that they're going to play the actual whole 47, 48 seconds of the video. We're going to get to hear everything that's said, where it's not just cherry picked by, law enforcement when they're just kind of wanting to get certain sound bites from that sound, but we'll hear it. And then I think that they'll probably try to find some kind of evidence of Alan speaking somewhere. Like whether, I mean, I think we all would want to hear a voice comparison, right?
You think they'll do that in the trial?
I would try. I mean, if I'm the state, I would try. If I had the ability to be able to have, or the defense, whichever one, if they're like, I've never heard Alan speak. So if he sounds like, a high pitched dude, if his voice doesn't sound anything like that, then like I'm almost contemplating putting him on the stand just so the jury can hear him speak in order to try to rebut the bridge guy video, So yeah, I don't know. But like, to go back to your original thing. So I know you've been big on the plea thing.
Well, I guess what bothers me is the whole people using the term practice trial. Like, it just seems like so frustrating. And what's the only way around that would be to offer Richard Allen something, if and bypass that by just having him waive his rights to appeal it, and then they don't have that issue anymore.
Yeah, I mean, I think that the problem is, and I've heard arguments being made and concerns from people that they're not sure if Allen knows whether or not he can plead guilty. Like that people are questioning whether his lawyers are letting him know whether or not, or that he just has the right. He has the absolute right. That's one of the three things that defendants have: an absolute right. You can decide to plead guilty or not guilty. You can decide if you want a bench or a jury, and you can decide, and it's all up to you. Your lawyers don't have anything to say about it, whether or not you're going to testify at trial. Those are completely in the absolute control of the defendant. The attorneys don't have anything to do with it. The one thing that I would say, kind of to rebut that, like I can't see any lawyers doing that. These guys have been practicing a really long time.
It's part of it. Then they're expecting the appeal. They're ready for the appeal.
Right. And they have to do everything that they can on the front end. They have a job to do, and they have to perfect all the issues for appeal. So everything that you see them doing that people may take umbrage with, I think that people just don't understand that if you don't do certain things in the pretrial phase, during the litigation phase of it, you waive that issue for appeal. So everything that you see these guys doing in terms of offers of proof are done for the purposes of, in the event that there's a conviction down the road, that they've preserved the issue for appeal, because you don't want ineffective assistance of counsel. No one wants to try this case again. Like that thing that you were saying, what really bothers you is you're hearing about this, this is just going to be a practice trial. And that's what I'm saying. Like everybody that was cheering from the, Richard Allen is guilty camp shouldn't have been thrilled with that ruling by her, where she's essentially not allowing them to put on a defense. Because if you do any modicum of research into third-party culprit stuff, it appears to me that Judge Gull has some kind of expectation that they essentially have to solve the case in order for them to put on the defense, and that's just not how third-party culprit stuff
that was another
works.
question. Do you agree that there was no nexus?
No, I think that there was definitely a nexus. I mean, they couldn't, like, let me put it this way. Like, let me ask you a question. Had they been able to put any of those dudes through their cell phones at the bridge that day, do you think that those guys would have been arrested based on everything else you know?
Yeah, and I think that would constitute a nexus. But they don't have that.
But you're that's what that there is no nexus. They're now the defendants. That's what I'm saying. Like, you don't need to solve the case if you're the defense in order to bring a third party culprit. The nexus is love it or hate it, like, I don't care what Elvis Fields, education level is, or his intelligence level is. The guy put himself at the bridge the same way that Allen did, with some specificity. Now, you had Murphy get up there, and he kind of backtracked it, but or I wouldn't say he backtracked it, but he prefaced it by saying, "Yeah, at first they thought he was kind of full of shit. I thought he was messing with me." When he talks about Fields, when he makes the statement, so I mean, I think just kind of the odd similarities between the things that Holder was posting and the way that the girls apparently are staged. Now, I've never seen the crime scene photos. I still, to this day, I've had a million
Either have
people
I.
offer them. I don't want to see them. I've never
Me neither.
asked for them. I've rejected them. It's not my game. Like,
I don't
that's
think
not
you
my
need
thing.
to.
I don't want to. Like, I don't even want to see them in court. Like, honestly, if like I'm going to sit in on that trial, like, I have no need. And they were very careful about not showing the gallery what they were showing in those 3 days of hearing. So if that's kind of a sign of things to come, I think that, especially for respect for the families, they're sitting in there, they don't need to see it. Either family, whether it's for the girls' families or Alan's family, because if it turns out that Alan's the dude, I mean, Kathy and his mother are perfectly nice people, or victims in a much different way, but victims nonetheless.
I
It's
agree.
like there's I mean, cases like this are just awful, like, all around. And it's like, as a defense attorney, I've handled some cases with some pretty awful people, and I've become close with these family members that are mortgaging their entire lives to try to defend their child, and they had no idea, that their kid was capable of it. And I mean, if you could imagine, if it was your child, I got 4 kids, man, like, that's your worst nightmare, to turn out that your kid or your spouse turns out to be a monster, man. It's like, how do you even handle that? So, I try to be respectful of everybody around there, and I always have been. People give me a lot of heat about, like, oh, no, no, no," and I'm like, I didn't try to co-opt anything. What I've been trying to say is that exact issue that you have, is that use of the word a retrial, to put family members through a second trial because the law has been violated constitutionally. And just, if you look at appellate issues, it's hard to get a retrial. But a lot of the things that Gull has done have really made it almost a distinct. Like, if you just ask, like, a scholar, like legal scholars, in terms of her rulings, have she made it like a distinct possibility that if he's convicted, he's going to get a retrial, just by way of some of the decisions she's made. And I think, to a person, everybody that has a lot of experience trying cases and understands appellate law, is going to tell you, yeah. That's why I'm saying, like, everybody was cheering, oh yeah, the third party you should have been like, all right, they got strong evidence. Let them do their third party culprit thing, because we know that they can't put those guys at the
There's
scene.
there's
Let them
rules,
do it.
right? Let me
Yeah.
read this real quick. This is R versus McMillan. It says here, evidence directed to prove that the crime was committed by a third person rather than the accused must, of course, meet the test of relevancy, must have sufficient probative value to justify its reception,
Probative.
consequent probative value to justify the reception. Consequently, the courts have shown a disinclination to admit such evidence unless the third person is sufficiently connected by other circumstances with the crime charged to give the proffered evidence some was it
Probative.
probative
Yeah. Yeah. Probative.
probative value.
Probative.
So what part of the nexus that you say exists isn't speculative?
I mean, the fact that I don't think that Elvis Fields making a statement that he was there that day and left DNA on one of the girls is speculative. I don't think
Well,
that.
he said what if.
Well, I mean, if we're gonna parse words, you
I
know,
mean, no, that's quoting him, right? He asked the question,
I don't
what
know if it's
if?
quoting him or not. Unfortunately, I don't think the thing was recorded. So, I mean, there's going to be a paraphrase.
So then we have to
Unfortunately for.
speculate.
Well, I mean, maybe you could argue. I don't know that you have to speculate. He definitely put himself at the scene in a hypothetical type of way. It's an awful strange question to ask,
Yeah.
and I think that you know, when you have the connection between Holder and his son and the girls, when you have just this like, and again, I don't know if the sticks and just the way that the crime scene looked is BS or not. You know what I mean? Like I have no idea. You know, I've never seen the things. I'm not an expert in that type of thing. I think that that's something that ultimately, when the appellate court looks at it, if he's convicted, they're going to be like, there was enough there for her to allow for it, you know, and like if I'm the judge, I'm erring on the side of caution because I don't want a retrial. I'm going to say, okay, you know, if the state's evidence is powerful enough, if they've got strong enough evidence, if they're that convinced in their case, then let them bring in some modicum, even if it's like what they did in Reed, where she basically said, I'm not letting you put that defense on in your case in chief, but I'm going to let you cross-examine about it. You know, that's how I'm going to allow you to do it. I'm going to give you a short leash. I'm going to allow you, because like ultimately at the end of the day, to me, if you're Gull and you sat in those 3 days of hearings and you heard Murphy and Click under cross-examination from Nick McClelland when he asked point blank, you could not put any of those 5 guys or 6 guys at the bridge that day, could you? And both guys had to say no. You could not put any of those 5 guys, 5 or 6 guys in Delphi that day, could you? And they had to say no. I mean, that's powerful.
Yeah, that's what I'm referring to as reasonable.
Right, and then you avoid any potential pratfalls down the road in terms of appellate issues. Because I'm just telling you, that's going to be a major issue. That, and what shocked me more than the third party stuff, because we all know she hates the third party culprit theory. She hates the Odinism. Like,
well, it looks like it needs to be outlined. Let me read this here. The factors for a judge allowing the third party suspects are listed here. This is what I'm basing my opinion off of. The assessment of admissibility balances probative value against prejudicial effect. The court should consider factors including the danger the evidence will arouse the jury's emotions and prejudice, hostility, or sympathy. The danger the evidence and any evidence responding to it will unduly distract the jury. And that's one of the things she listed. Don't you think that that's correct?
No, I think that, I mean, partially. He added the more probative or prejudicial than probative argument is a different thing. I don't think they're going to confuse the jury. I mean, essentially what she's done, I mean, just kind of look at it this way. She's basically denied him putting forth any type of defense. And it's not just with the third party culprit stuff. It's like, what I found more shocking is that based on no real argument, no real scientific evidence put through by an expert, is she barred the geofencing data. Like that, to me, that's going to be a much bigger deal. And Nick McClelland is the exception to the rule of prosecutors in this country. He is probably the only prosecutor, or maybe a handful of prosecutors, that are saying that geofencing data is unreliable. Like, and he is on record. He has completely destroyed Carroll County's ability to be able to ever.
I'm having some. Hold that thought. I'm having some feedback here. I'm going to reset. It'll just take a second. Okay.
Okay. Yeah, I use StreamYard too. It happens.
Okay, sorry about that. I was getting
no worries. So yeah, I mean, like at the end of the day, that geofencing thing, like I was saying, just like Google it. Like, don't trust me. Just Google it right now. If you're in chat, just say like who typically uses geofencing data? It's typically the prosecution, and it's typically the defense that's seeking to keep it out. Here, you have the opposite thing happening, and you have McClelland, huh? I didn't hear you.
Hold that thought, Motta. I'm going to kick you out of here for a second. I'm going to kick you out and then join right back.
Do you want me to? Do you want me to jump out completely? and jump
It's
back
not
in?
it's not you, it's not you, it's me, so as soon as I kick you out, just come right back in, okay?
Okay.
Okay, sorry about that, guys. Hopefully you can hear me. I was having some feedback. Bob, if you can jump right back in. Hopefully that fixed it.
Yeah, I went all the way out, so hopefully that
Yeah,
works.
this horrible, like, staticky sound, but we're good. Sorry, what continue?
So I was just saying, like, I think that the bigger issue on appeal, if there's a conviction in this case, is going to be that geofencing thing. Just like I was saying, like, just look, like that is, if you ask experts in the field who know not a lot more about geofencing than I do, it is way more accurate in terms of location than pings off towers.
I agree
Like,
with
it's
you on
just,
that.
you know, and like Nick is literally like, he argued it. He was saying, he's like, no, he's like, we don't even use geofencing to get warrants, like in Carroll County. And I'm like, man, that is like, he is like just destroyed their ability to be able to use geofencing data to get warrants in Carroll County
In
forever,
the
because they'll
future, yeah.
always be able to go back and say, remember that time Nick said that this shit was unreliable? So I like, that blew me away. That
Is that
absolutely blew
specific
me
to
away.
what the argument is, though? Is it specific, or are they throwing it out because they're trying to tie it to this, third
I don't
party,
know,
like it's
man.
part of the
I
whole.
mean, like, I have no idea. Like,
But yeah,
I
it is,
mean,
I agree with you.
if
If
like,
anything, it would help the prosecution.
right. I mean, what, like, I think that everybody, most importantly, that the families of the victims deserve to know who was, like, if those phones were there, why aren't we trying to figure out, like, this isn't a game. This is people's
Yep,
lives.
exactly.
You know, like this is like I'm all about just trying to get to the truth. And like, it drives me nuts, dude. Is like a defense attorney when I see cases where, like, all right, well, the DNA technology has just advanced so much from where it was years ago. Like, why aren't they like, if there's ever a question that DNA technology now can answer about a case, why aren't you testing it? Yeah,
What about
like the whole
retailoring
thing
it?
with like
Can't
the
they just
West Memphis
retailer all this
3,
stuff?
man. Huh?
Can't they just retailer it and kind of rephrase how they're presenting the
Yeah, I
evidence?
mean, not, you talking about the defense?
Yeah, the defense, instead of applying it, to this third party suspects or alternative suspects, can they still present it to kind of exclude their client?
Not really. I mean, not on her. I mean, what she's going to allow them to do is that she's going to allow them to do the offers of proof, which she has to. She has no choice in that. Like, they have to be able to do it, because, like I said, like, really the entire point of them doing that. And again, she'll excuse the jury. Like, that's not going to be done in front of the jury. They'll call witnesses up there. They have to do it in order to preserve the issue for appeal. Because at this point, like, if you're the defense, I mean, look, you're going to have to just say, she's ruling how she's ruling. Like, I'm sure if you were to ask Baldwin and Rosie if they were surprised by her rulings, they would have said absolutely not. We were anticipating it. You know what I'm saying? So
Mhm.
they'll do what they have to do. And like I said, like, they're going to have to attack the timeline. I've been saying it forever. Like, I think that the state's biggest issue is going to be able to prove at what time, or give even a close estimate. I mean, stomach contents are going to be a big deal here, because we know, at least according to what was said in those hearings, that they did not take the body temperatures of the girls when they discovered them, which is huge in terms of, because you can walk that backwards and say, okay, well, the body temperatures are 58 degrees, and this is the ambient temperature outside. This is what makes sense in terms of walking it backwards. This is a pretty accurate time as to what we believe the time of death is. I mean, like, the scientific evidence beyond just the video is going to be at issue in this case. Like, if the defense is doing their job like that, I'm just telling you, if Allie and I were handling this, that is what we would be attacking forget about the third party stuff. You're never going to be able to place those guys there. If you attack the timeline and you can get some kind of movement in terms of the state saying, well, yeah, we can't say definitively we know when the girls were killed. We can't say it scientifically. That then brings into question, because the presupposition by Gull when McClellan said that Holder had an alibi and that he was alibied out, it like is completely reliant on the fact that
But it was
she
checked.
well, but no, that the time of death is accepted by Gull as being accurate. That the 2:30
But
to
that brings me back
3:30.
to the kidnapping aspect of it. It's almost like the reason they approached it that way is because they really can argue any theory as long as they can prove Richard Allen was the person kidnapping the girls at a specific time.
I mean, but like, I don't know. I mean, dude, you have to admit, like that looks like. Have you made the trip to Indy? I know you're out
No,
west, man.
no.
Dude, that literally looks like every Midwestern dude. I've grown up in the Midwest. I live in Chicago. I went to like school in Central Illinois, man. I live in it, man. Like that.
I
Every
get that, but if
dude,
not Richard Allen, who though? Who is that?
like, I don't know. My question has always been is like, who's going to be the actual expert that's going to be able to say how tall? Like, who's going to do the actual like scientific evaluation of how tall that dude is in that
That's a
video?
good question.
Because
Are they even going to admit that video
I don't
anymore?
know. Like,
That's been a big
don't you want to
question.
know that? Because like
Yeah, I do.
Richard Allen is small as hell, dude. Like the first
Yeah.
time I laid eyes on him, like back June of whatever year that was, 2022 at this point, I don't know when it was, 2023. Like, and he walked in the courtroom, I was like, I couldn't believe, like, I like audible. I was like, holy shit, he's like a little Laputian. Like he was like by far the smallest guy in the courtroom, you know? So it's like, and that was the thing that I was saying. I'm like, every single person that would see Allen, the first thing that the first identifier would be is that he's really, the guy was really short. Not short. Like I have a friend who's 5'5". Like, well, he's one of my best friends. And like everybody, the first thing they say about my buddy is that like he's a really short dude. He's like super short. Like if they're like, who do I look for? I'm like, look for the shortest
Yeah, I'm
guy in the
short
bar.
too.
Yeah, like, I mean, so like Allen is very, very short. Like that would be
Well,
so
he's short
when
and tiny.
well at that point in time, like Allen's weight was up. You know what I'm saying? So like the weight would seem to fit there in terms of if you're looking at if you're forgetting like height, if you're just looking at body type, like at that point in time, Allen was much heavier, right? Like at the time of arrest, he was probably more kid. But again, this is 2017. You know what I mean?
The time
So
of the murders, he was very skinny.
right. So like, I don't know, man. I don't know. You know, it's like
Let's see.
it's
Last
like I mean,
question,
we
if you
just
want, and then we can do questions from the chat if you want.
okay, yeah, awesome.
Let's see. Actually, I think you already answered all of my questions, so let's go here.
Wait, here, I don't know if I really answered your waiver question. So with the plea deal, and it's actually a very intuitive question. Like typically when you're trying to work out a plea deal, uh, and it can come from either side. Like a lot of times, what they do in a case like this, where the death penalty is an option, is early on to avoid going to trial. The state will elect on the death penalty, and then the first offer is, here's our carrot. This is the benefit. We're going to offer you life without the possibility of parole. We'll take death off the table if you plead out.
That's why I was asking about the death penalty.
Yeah, so like he didn't do that early on. And I don't know why. I like so, but as to the issue of the waiver of appeal, it's kind of like I've looked it up with you know, kind of Indiana law, and the issue is always, was it knowing and voluntary? Like, so did they knowingly and voluntarily waive their right to appeal? Because if you're thinking about it, forget about the law, you're just thinking about it common sense wise. You're like, all right, dude pled. Like, how is he going to try to turn around and appeal it? Like, he agreed. They made an agreement. Now he's trying to break the agreement and go back and appeal the case. So, and by way of that, it's a very narrow issue anyway.
Garza versus Idaho.
If you don't go to who's that?
Let me put it up on the screen.
Uh,
right here, signed 2 plea agreements, each arising from state criminal charges, each containing a clause stating that Garza waived his right to appeal. Shortly after sentencing, Garza told his trial counsel that he wished to appeal. Instead of filing a notice of appeal, counsel informed Garza that an appeal would be problematic, giving Garza's appeal waiver. After the time period for Garza to preserve an appeal lapsed, he sought state post-conviction relief, alleging that his trial counsel had rendered ineffective assistance by failing to file a notice of appeal despite his repeated requests.
Yeah. So, and here's what the deal is with, so there's, if I don't know how much you guys know about the appellate process. So the direct appeal is the first appeal after trial. So they call that your direct appeal, the first thing that you fire off. And again, direct appeals are only specific to issues that were brought up at trial. Like it is not the time to bring in other issues. Okay. So like they're not going to be like, that is all post-conviction relief act stuff. Okay. And that is after you file your direct appeals and you lose those. That's when you can bring in things like newly discovered evidence. Like that's what you're always hearing about when people are getting exonerated 20 years down the road. Oh, the new DNA testing exonerates our guy. So that's newly discovered evidence that couldn't have been discovered at the time that the trial took place. So it's truly newly. So with the appellate waiver, almost in every single, in the language of a plea deal, if they're going to write it out, there is an appellate waiver saying that like you are waiving your right to appeal, which is a huge give for the defendant, because that's a big right to be able to appeal your case. So the concept that it has to be knowing, because where it becomes an issue is when that person actually stands in front of the judge and pleads out. And you've had cases in Indiana, and my friend who's brilliant, she takes heat, but she's brilliant. But Kara Winicky, like she's written extensively on this. She's a brilliant lawyer. Like people like attack her and it's unwarranted because she's brilliant. I mean, she's a defense bar lawyer, make no bones about that. But you know, she puts together some amazing little posts, and she addressed this issue explicitly. You know, that what happens sometimes in a couple of cases, and there's a case called Creech v. State, which is an Indiana case, wherein the judge misadvised. So you've got a plea deal with the state, the defendant, and his counsel, where they all agree, all right, you're going to plead. This is what the offer is. You're getting a benefit. We're shaving a couple of years off. You're pleading out on this thing. You got your benefit. That's why you're accepting the plea deal, and you're waiving your right to appeal this down the road. And dude's like, yeah. So then when he gets in front of the judge is like, just so you know, you have the right to appeal. So he's now been told on the record, he's been misadvised by the judge that he has the right to appeal when he's waived it. So like, that's the issue that kind of pops up sometimes, where if he knowingly and voluntarily waives and he's not misadvised, it's in stone.
But if they don't have the death penalty on the table, there's really no reason for him to do that, right? And
there's no reason for him to plead.
This case right here is what gave me what put the thought in my head was Edwin Hall and the murder of Kelsey Smith. They right from the beginning, they put the death penalty on the table. So when they made a deal with him, he waived his right to appeal, and then they took the death penalty off the table.
Yeah, that's what I'm saying. Like that would have been McClelland's move early. You know what I'm like if I'm McClelland, when I'm looking at the case and you and I have a difference of opinion, which I respect, about like the strength of the evidence coming in. If I'm looking at it and I'm McClelland pre-confessions, and I'm like, all right, you know, we got mere presence at the bridge, and we got this unspent casing, which they're going to attack. Like we have no idea. They could have more. Like I don't know what they have. You know what I mean?
Think they do?
I don't know, man. I really don't. I think that there's going to be issues. Like what this is going to turn into is the attack on the investigation and the processing of the crime scene. You know, like she's left them no choice but to attack how they investigated the case. It's going to be a full frontal attack on.
What about the DNA?
I mean, like, what DNA do we know about?
Exactly.
I mean, like, I don't like if they have DNA, that's a problem. If they've got Alan's DNA, that's
Maybe a
huge
partial
problem for the defense. If, like, I mean, then the case is over, right?
Yeah, I feel like we would already have known that.
That's what I'm saying. I've had dude, Sleuth, I've been doing this a long time, and I've had so many debates on this fact with people. Like in the last 2 years, the social media world and like kind of the online world has been like reading probable cause affidavits, and I've been doing it for a living. Like literally every case I've ever gotten that wasn't a grand jury indictment, I've read probable cause affidavit. So I literally done it professionally. People are like, "Oh, they always keep out the best evidence." And I'm like, "No, they don't. They don't do
No.
that." Like number
Maybe
one,
for a search warrant.
warrants are different. Warrants are different. You just
I think they get it confused.
I think they do too. I've tried to explain it so many times. I've had so many debates where I just want to smash my head against the wall. I'm like, look, man, like this is how it goes. The defense is going to, they know the defense can attack that in terms of quashing the arrest. They want it to be powerful. And it's the state's opportunity to get their theory out to the public. Like, and they want it to be powerful. They want to get the public behind them and say, oh man, they got the right dude. It's like, think about how, like, when I read the Rex Heuermann bail application, I don't know if you ever read that thing.
Yeah, I have it here.
Just stunning. Like the amount of police work they did on that thing. You're like, you have no doubt.
Yeah,
it's incredible.
It was amazing.
I mean, like unbelievable. And like, even like, I know that there's like this whole thing with Kohlberger and, you know, they're attacking that thing. But when I read that, I'm like, wow, they did some really good police work here. You know, it seems like they got this dude nailed to the wall. You know, how that's going to shake out, you know, because Ann Taylor over there is doing a good job. I mean, she's doing her job. Like, defense attorneys have to attack things. They have to make sure that everything was done by the book. That's part of the gig, you know? So yeah, man, let's take questions. I hope I
real quick before we do that, let me follow up. The Holman interrogation, I feel like if they would have had a solid DNA match, it's very important for him to get that confession. I think he gave the information about the bullet. If they had solid DNA, I feel like they would have brought it up during 100%.
And remember, Sleuth, they can lie. They're allowed to say things like they're like, I mean, they're like, that's what I'm always saying. Like,
but it doesn't mean everything's a lie, though.
No. But like, what they'll do, like, you'll see it all the time, especially when they have two guys in.
Yeah, well, he said we have an expert that matched your voice. He said stuff like that, which was probably
right. But like, there would have been no issue if they would have said, "We got your DNA."
Yeah, he would have confessed, maybe.
Right? Like, there was nothing stopping him. Like, the Supreme Court of the United States says that cops can lie in interrogations in order to elicit. You know, they can't lie about certain things, though. They can't lie about, like, oh, if you tell me, I'm going to set you free. Like, they can't lie about that. They can lie about things that they say that they have in order to try to get that person to talk, but they can't make up like just whole cloth saying, oh, if you confess right now, I'm going to let you walk out of here. You're a free man. Can't do that, you know? So there's limitations, but in terms of kind of being able to weave through an interrogation and try to get them to talk, they can obviously go in there and say all kinds of stuff. And you would have thought that if they had it or if they didn't, I mean, he could have said it either way, to be honest with you.
Yeah.
At that point in time. But yeah, I mean,
well, I apologize to everybody who's put a question in. So if you want to repeat your question now, I'm going to zip all the way down to the bottom of the chat, and we'll start here with Ruckus Rocks.
Okay.
This is Bob. Do you expect an emergency continuance?
I mean, from my experience, every day that passes, the closer you get to trial, the judge is going to tell you to pound sand, you know, like, and go, like, for the second time, they've sent out 600 jury questionnaires. She won't grant it. So I really think they could ask for it. I don't think she'll grant it. She's going to be like, as far as we know, and there was a deadline set on it, and it was, the last piece of discovery that was still outstanding, which was the most recent extraction of Libby's phone, which he wanted to use the most updated Cellebrite. And I think that was due mid-August.
Well, tell them what Cellebrite is. It's the digital forensics, right?
Yeah, yeah, that are super effective. Like
It was what was used with Keegan Kline, I believe.
it was used against the first time I ever ran into it is against my client Anthony Garcia out in Omaha, which was like that, like the similarities between, like, I mean, they hated us out there. Like we were like Chicago lawyers coming in, oh, the big city lawyers, and I'm like, man, I live out in the cornfields, bro. I'm like 45 miles west of, but you know, it was like my old man and you know, and it was Allison and I, and they just hated us, and it was just, yeah, it's there's no way they're going to grant it. Like if they ask, there's no way that they'll grant. They're going to trial. Like everything that they need, they've had the time, they've got the money to hire the expert. It's like it's trial time. She's not going to, even if they ask, she's not going to grant it.
And then they're ready for the appeal right after.
I mean, they'll have to. Well, they'll always file. So the way that you do it is within 30 days of conviction, you got to get a notice of appeal that you're appealing. And then, you know, the appellate court gives you time to file the briefs, you know, and on direct appeal, like I said, they're very limited in terms of the issues that they can bring up. You know, and ultimately it's a balancing act for the court to, you know, if they're like, look, this is harmless error, you know, if you're looking at the manifest weight of the evidence that the state presented, and we look at what you're saying this error was, well, if we weigh one against the other, that's not going to outweigh the evidence that the state put forth at trial. So we find it to be harmless error. That's why we're like, you know, if the Supreme Court hadn't fixed Gull removing those guys, hate him or not, she was not within her ability to be able to do that at that point. I kept saying it. People were like, oh, they're idiots. I'm like, dude, I'm like, they're counsel of choice. I'm like, I'm just telling you, you don't want this to, if you want Allen to be convicted because you believe he's the guy, you don't want that happening because it's structural error. Structural error means automatic redo. Like there is no balancing. It's like you screwed up, you violated his Sixth Amendment right, you took his counsel away. But so the Supreme Court fixed that. They realized that up there.
That's why they're there, right?
That's why they're there.
Now, here's another question for you, Bob. What do you think of the alleged misconduct on the part of the defense team? Is it behind us now or still in play?
I mean, like I had a very different opinion. I took so much shit, like because like
well, you're in hostile territory right now.
No, sure. I know, and dude, like I've like I tell everybody I'm always up for the conversation. I love this. I argued for a living for 20 years, man. That's what I do professionally. I love hearing the other side of it. I love having this conversation with you, to be honest with you. It's like you're the first person that's you know had the courtesy to be like, hey man, come on the show. Let's talk it out. I think
the timing is right.
Yeah, I do too. And you know, and it's like, and I would have had this conversation a year ago. You know what I mean? It's like this is just like I'm always open to conversation. I'm always open to hearing everybody's opinion. Like to just kind of like be like just locked in on opinion to the exclusion of everything else that anybody else thinks is ridiculous. You know, it's not how, can't go through this life doing that, man. You got to be able to really be able to, you know, kind of listen to the other side of it, because somebody might say something that you're like, oh, yeah, I didn't think of that.
Well, if you're open to it, which you should be, if you're
everyone
looking,
should be.
And they need to catch the right guy.
God,
first and foremost.
Dude, I mean, for real.
I just feel like the evidence is definitely damning towards Richard Allen. I think that's just where we might disagree.
Look, if I'm being intellectually honest, do I love the fact that he put himself there? If I'm his defense attorney, no,
because that's their nexus, right? That's their nexus.
Like, that's their nexus, right? And you know, and like that's what I'm saying. Like in terms of pure strategy, if I'm the defense attorney for Richard Allen, I am focusing on attacking not just the investigation or lack thereof, because we've all heard rumors. None of us really know how great or how poor it was. We'll find out at trial. Like that's what I'm always telling people. I'm like, well, we're all speculating. Like I don't speculate. I don't know what the evidence is. We'll find out at trial. Let's just wait. Let's wait. Like they know, you know, and like the other thing, kind of like for my counter on the plea, which I know you've been big on, is the defense knows what the evidence is. They know what it is. And they also
I'm just trying to figure out the only way to avoid an appeal would be for them to offer some kind of a plea. And then,
yeah, I mean,
that's where I'm going with that.
That part of the system is just,
I could be wrong. What do I know?
I mean, but like Allen's got to agree to it. You know what I mean? Like Like what kind of, like, because at this point, Alan has nothing to lose. And she's given them being Rick, really, really good ammo for appeal. Okay. Like she has just armed them with legitimate appellate
You think
issues.
it's a given? They'll go ahead and they will appeal it and it'll be
I
accepted?
never say anything's a given in the law, dude. You never know what an appellate court's going to do. You can look at the law. You can say, like, historically, this is what they've done, but you can never, nothing's a given in the law. Like anybody who's saying, I could guarantee that is full of shit. You can't do no one can do that.
Too many
Like,
variables.
yeah, there's always variables, and you're dealing with human beings who all have their own
The biggest
perceptions.
variable.
Exactly. And we all think about things and perceive things in different ways. And like I always tell people, I'm like, that's what the law is. Like the law is literally two people looking at the same exact thing and interpreting it in two completely different ways.
Left and
And then
right
they're
brain.
going and arguing about, right, sky's blue. No, it's purple. It's clearly blue, you know, and then they're going and they're
No.
fighting to the death over it. So, but that, like, and that's what it is with statutes or evidence or anything else. You have two different interpretations of the same thing, and that's what really the law is. That's like what we do for a living. So, yeah, I just like I think that they took that away, and I'm talking about the state in terms of them being able to get him to plead out because now he's got nothing to lose.
Yeah,
You know
no
what I
death
mean?
penalty.
Unless this concept of, and look, just so everybody knows, like every attorney, doesn't matter if you're a prosecutor or a defense attorney, every single attorney holds their hand up and swears an oath that they're going to uphold the Constitution, they're going to uphold the law, they're going to zealously advocate for their clients. That's it. That's like we all swear to the same thing. And one of the things is if McClelland ever made a plea offer to Rick Allen, they are required. It's not a choice. They can't say, "Yeah, we're not going to tell our client about it." They have to tell that. They have to present the offer to Allen.
You don't think that's happened?
Well, if it had, like, I don't know.
Would we
But
know?
like,
Would the public have any way of knowing?
we wouldn't know, and it's not something that would necessarily come out.
Like during the status hearing, maybe.
Right.
during
I
the
mean,
closed
they
session?
may have talked about it. Like we're all speculating on what may have gone
Yeah.
on in that closed hearing, which was weird. Because
Yeah.
like typically status hearings are just that. You're going in, like in a regular case, like we'll have a status hearing every 30 days.
And then
because the
look at
judge wants
Richard
to
Allen's
know.
face too while you explain that. I mean, he just looks different here.
Yeah, he does.
What the hell is going on? He's got his glasses and he's holding a folder.
Yeah, I couldn't tell if that was a folder or like a yellow legal pad. Yeah, it's something. He's got something.
Yeah.
He looks like he's, yeah, I don't know. That was
What
a
is
strange
that?
shot.
So,
I don't
yeah,
know.
very strange. And he's not wearing his that jacket anymore.
I think, well, so this is post him getting out of Wabash, right? Maybe
It was the
he's
day
just
it
in a
was
great mood because he's in cast now.
because he knew that. This was actually before she made that decision. It's like
Oh, was it?
he must have been anticipating that maybe.
Maybe. I don't know. She made the
Yeah.
right move there. At that point, he's
I
like
agree.
in cast. We're 2 months out, 3 months out from trial. Just keep him there, especially because the cast sheriff's like, I don't want him, but we can take him. So like that was the move. Let's see. Respectfully, why choose to be defined? Oh, God, I love this question.
Yeah, this is
Dude,
the kid gloves are off on this one.
Yeah, no, this is my favorite question, and if like, I highly recommend, Purdue, that you check out my channel because I explain it too. So that's what people think that defense attorneys do. All right, we're always trying to get off the murderers. The reality in the criminal justice system is that most of the time law enforcement gets it right. Most of the time they have powerful evidence, and over 90, I'd say, like, depending on the jurisdiction, over 92, 93% of cases are pled out. Very rarely do cases go to trial because the fact of the matter is typically they have the evidence. I'm not trying, like, what my real job is, what the real job of defense attorney is. If something's going to trial, either one of two things is true. Either you have an obstinate defendant who's like, I'm going to trial. I don't give a shit what evidence they have. We're going to trial. Because again, remember, the defendants have three choices that are entirely theirs: go to trial or plea, testify or not testify, or bench or jury. Like those are completely in the purview of the defense, the defendant. So what we really do as defense attorneys is we protect. That's why, like, we protect us, all of us, from the government. All right. Like, and it's the easiest way to explain it. So when you see it, so remember, the Constitution was a document that was written by our forefathers, all those hundreds of years ago, 400 plus years ago, wherein we had just gone to war against England because we didn't like the way that England ran their country. We didn't like their criminal justice system.
Damn red
We didn't
coats.
like we didn't like the fact. I'm going over to England in September. I'm super excited for the first
Yeah.
time.
You
Bring
tell them what I
kids.
said.
I will. I'll pass the word. So that document was written for us, the citizens, telling the government, this is what you cannot do to us. So when you see situations where a defense attorney has filed in a case that they filed a motion to suppress evidence and that they're alleging that the law enforcement violated the constitutional rights of that defendant, you don't blame the defense attorney for calling the government on them violating the law. So what you do is you get pissed at the cop who violated the law. And the reason that we do that is it's not just for that defendant, it's for all of us. If you don't have defense attorneys filing motions to quash, filing motions to suppress, that is going to let law enforcement do whatever they want, whenever they want. So like the real finger pointing in those situations. So say, for instance, on a drug case, if I'm looking through the discovery and they didn't have probable cause to pull the guy over, like they made up something, and then they go in, they search the vehicle, they find the drugs. I'm going through the discovery. I'm like,
Fruit of a poison tree.
Fruit of a poisonous tree. I'm like, the search stinks. They didn't have probable cause. They just like now they're using like the smell of burnt marijuana. That was their probable cause. Like, and there was no way to disprove it. Like, how could I like disprove it as a defense attorney? I'm like, well, so he's saying he pulled him over initially because he went over the double yellow line, which is technically a traffic violation, which the courts have found is enough probable cause to pull them over for that. But then when he rolled his window down, I smelled the unmistakable smell of burnt marijuana, which gave me probable cause to go into that car and make that search. So, but the point being is that when we file those things, if the cops follow the rules, if they don't violate any of the constitutional rights of the defendant, if they just follow the rules and they know what the rules are, that's the one thing the cops are trained on. They know what probable cause is. They know what they need to do in order to get a search. They knew like it's either got to be plain view. They saw something on the center console, or the person opened the door to their house and they peeked in and they saw, a kilo of Coke on the table. They're like, hey, I just saw that. It was in plain view. I'm coming in. So if the cops don't violate the law, guess what? We don't have a motion to file. Right. So like that's the overarching concept. Everything that we do is to protect our rights as citizens. And that is gospel. No one's doing it. Like, understand that the cops and the prosecutors are the government. That is the people of the whatever state. The cops are paid by the government. They're government employees. So defense attorneys are the last line of defense in terms of literally protecting the constitutional rights of the citizens of this country. That's what we really do. My job as a defense attorney is to make sure that my client got a fair trial, make sure that my client understands his rights, make sure that the police did their job properly, and make sure that the prosecutors did their job properly. That's what it is. And if they have the evidence, typically 99% of the time, the defendant is convicted.
So what if you find evidence that, through your process that your client is guilty?
Well, so the reality is, and like the first thing that my dad taught me coming into like criminal defense
It's like
attorney,
an ethical question, I guess.
right? It is. It's the number one thing. So like, remember, my dad was like Gacy's lawyer. So like the first question
Yikes.
everyone we used to ask me is like, how could your dad defend that monster? And I'm like, all right, well, and then I'm like, how long do you have? Like, how bored do you want to be by my explanation? But like, first of all, remember, Gacy was an insanity defense plea. Or defense. It was an insanity defense case.
Wait, Gacy's the clown, right?
Gacy's the clown. Yeah, 33 victims, 27 of them buried, like a monster, absolute monster. So that case was.
He had priors, though, right?
Well, oh yeah, he like on my season of my podcast where I just scorched the Chicago police because they should have had Gacy
He had
after
like a
3
sodomy
victims.
charge, didn't he?
He
Prior
did.
to all that.
And he had a 10-year bid in Iowa.
And went and restarted his life somewhere else and
Well,
became kind of
no,
popular.
dude, so listen to this. So back in the day, back before, you know, because it was a man-on-man crime. So back in the day, in the Stone Ages, they didn't believe that a man could rape another man. So that's why they came up with this sodomy charge. Like now it would be aggravated sexual assault. Like in our day and age now they realize it doesn't matter what your gender is. You can sexually assault whoever.
Rape is rape.
The right rape is rape. So back then they nailed him with a 10-year sentence. He ends up only doing a year and a half, like pulling the shit that Gacy. So he's out. He theoretically should have been in prison from, like, he was sentenced in 68. He should have been in prison from 68 to at least 77, which is the entire period of time in which he was killing. So like him getting out, and then they accepted his parole in Illinois, and that's when he moved to Illinois. And so that's when that whole thing went down. But the question with that case was, it wasn't Gacy saying I didn't do it. The question was, which is, if you're talking about the insanity defense, honestly, like every defense lawyer will tell you, it's the absolute defense of last resort. It's the hardest thing to sell to a jury. Like a jury is just not going to ever buy, especially when you have that many victims, that this guy just had a compulsion that he could not control.
It's usually up to the judge, right, at the last minute to decide that, right? Like, well,
no, like in that case, it was 100% the jury. And as soon as Bill Kunkel, the lead prosecutor during the trial, said, well, you know what? If you guys find him not guilty by reason of insanity, I'm just telling you right now that there's an off chance that he could be cured while he's in the hospital and he walks the streets
miraculously.
again. Everybody in the jury's like, yeah, all right, he's guilty. So it was like, you know, and it was, you know, but like, to me, as a criminal defense attorney, I realize that a vast majority of crimes that are committed in this country are as a result of either mental illness and or addiction to either drugs or alcohol or both, or a combination of mental illness and addiction. That's just the facts. I mean, that
personality disorders.
Yeah, like whatever the mental illness may be. And a lot of times that turns into drug abuse. You know, so like many of the crimes, and like we all kind of focus on the murders, but a vast majority of crimes in our country aren't murders. Like we just have tons and tons of crimes. The criminal justice systems are packed every day, the courtrooms, because there's batteries, there's burglaries, there's theft, there's drug dealers, all kinds of stuff, right? There's just tons and tons of cases. We just happen in kind of like our community to focus on the big cases, which always happen to typically be murder. Farmer, I don't know. I've heard rumors, and like I'm working with a former Chicago cop named Bill Dorsch. We believe we know where there's additional victims buried, and we've been desperately, because Chicago does not want any additional Gacy victims. We're like the victims' families deserve to know. Like I've had, so when I was doing my Gacy thing, like I had so many families call me and be like, we think that our son was a Gacy victim, like, and like the law enforcement won't do anything about it. And like Bill was like, he had a weird interaction with Gacy back in like before he was arrested, for like 4 years before.
He was a popular guy.
He was like Norm in Cheers. Like he was like a man of the people. He was a Democratic precinct captain. Like to me, he was the scariest of them all, because like more than like Dennis Rader and like the other dudes who seemed to like who were married and normal. Like
he was in your face.
He was in your face, having parties, 300 people parties.
He probably got off on that too, I think.
Oh, dude, like he was, of course he did. He was like the biggest narcissist. Like
that's how he got off when he first got reported, was because he was so well known.
That and the fact that like he just knew that the cops didn't care about like
he let a guy go, right?
Crimes.
He like tortured him. He like tortured him and raped him, and then the guy came and told on him.
Yeah, the thing that happened in Iowa when he was, you know, like everybody knows these famous stories that he was managing Kentucky Fried Chickens because his first wife's father-in-law owned KFCs, so he managed 2 of them.
3 of them, I think.
3 KFCs. Yeah. That may be true.
Yeah.
So he's like that was the one thing I wasn't focused like on my podcast about Gacy. I wasn't focusing on the Gacy story because I'm like, I've heard it. I don't care. Yeah, like I wanted to focus on kind
It's
of the
like Jeffrey
trial, the
Dahmer working at the
investigation.
Hershey factory.
Yeah, exactly.
Makes you wonder.
Yeah, but I hope that answers the question. Really, what defense attorneys do is we're not bottom feeders trying to get criminals off. What we're doing is protecting our constitutional rights. And remember, if the cops do their jobs right, if they don't violate the law, we don't have anything to file. And a vast majority of cases plead out. So really, the bigger part of our job is just trying to make sure that the penalty, what the punishment fits the crime. Like if I've got an 18-year-old kid that did some stupid shit and like not where they killed somebody, but like got in a bar fight, and punched somebody like too hard. And everybody
And
was
that happens. That happened
Yeah,
to
it
some
happens all
kids
the
that I went to
time.
school with. They were best friends and they got into a fight. He hit his best friend and he hit the
Curb.
countertop
Yeah.
and he died.
It's brutal, man. But like, say it's not even that extreme, but like if I have cases where I have like a 17 or 18-year-old kid that commits a crime that they charge as a felony, and like I'm going in and I'm like, look, this is a good kid. Look at this kid's family are good people. Like the kid made a mistake. Let's not, because if you hang a felony on somebody early in their life, they're done. Like you can't live life like you can't get jobs. It haunts you forever. It just never goes away. So like a lot of my job is I'm just trying to make sure that the punishment in terms of working out plea agreements, fits the crime. Because a lot of times prosecutors overcharge, and like they won't move off of it. Or, they'll take indigent defendants and they'll say, all right, we're going to overcharge it. And then they'll make an offer. They'll say, okay, here's the deal. They'll talk to the defendant who probably has a public defender because they don't have any money.
Kind of like spending 12 grand to go get a picture from Georgia.
Yeah, like whatever. What a mystery! What a great mystery that was. like that must have been like a first class flight.
I'm thinking a limo.
Went to California first, spent some time.
Train ride, maybe.
Yeah, that was an expensive expensive trip down to Georgia. I think I spent less going on my flights to England in a hotel. But yeah, it's like, it's just the practice of law is fascinating, and like you really need both sides. You want competent attorneys on both sides because we don't want to retry these things when they do go to trial. But again, like our real job is to just make sure that when we're trying to plead our clients out, that it's fair, that the punishment fits the crime. But like I was saying, like when you have an indigent defendant, what happens way too much in this country is that you have the state overcharge, and then they'll make an offer where they'll say, okay, well, we'll drop it down to a misdemeanor and we'll switch it from DOC time to, 3 months in county. And then they get the conviction, even if the person's like, I didn't do it. It's way too enticing of a deal for that person to risk going to trial, because you never know what a jury's going to do. There's been so many trials where Allison and I have tried cases and we're like, man, we crush that. Like, there's no way they're going to find our client guilty, because we never ask. I never ask my clients. It's not like the movies. Did you do it? I'm your lawyer. You have to tell us the truth. Like, if I have somebody who's accused of doing something horrific from the morality perspective, is a father of 4 and a family man, and I consider myself an empath. It's like I don't want to have to deal with me
and the protection of
my
rights
mind
too, right?
Yeah, it's like I want to be able to do my job properly, and if I know things like and to be honest with you, I've never had a client come in and say, yeah, I did it. Like, it's just not reality. Everybody's like, nah, hell no, I didn't do that. And then
I call it probable deniability for the defense. They love that.
Well, but the reality is the way it typically shakes out is that I get the discovery, and then I sit down with my client and I say, all right, like, I know this is what you told me initially in our first interview. This is what they've got, and these are real problems. Like my advice to you is that you let me talk to the state about a plea, because I'm just telling you, like, cases of law, trials, they're not like, I don't give a shit how silver tongued you are. Like, this is like, we're not beating this evidence. Like, we're not going to be able to overcome it. you need to let me go try to plead this thing out and get you the best deal I can. You know, so that's the reality of what happens when the state has a strong case. You know, you're going in talking to your client with the discovery and saying, look, this is what they got right now, and it's bleak, bro. You know, like this is not a case that we're going to be able to go in there, you know. But then you get the cases where, like we were talking about here with Allen, and they're like if I'm the defense attorney and I'm looking at the evidence, I'm like, you know, it's
Timeline and the bullet and all
maybe
that stuff.
right. We could beat this, like potentially if they don't, because they all know what evidence they have.
Something to work with.
There's something to work with. It's not like there's holes. There's holes in it, you know, where you could pick holes and kind of try to expose those and say, all right, you know, like they have a real problem with the time of death, which I think, again, like to me, like just looking at it from the outside looking in, I mean, that's what I am attacking full blown. Like I've been calling for that on my lives. I'm like, forget about the third party shit. You're never going to be able to put these dudes there. I'm like, if Ferenczi, Click, and Murphy couldn't do it, and you know they tried to put them there, you know, like
And
you're
they
not.
should. I mean, there was nobody was arrested. They didn't have any suspects, so
right.
they should go down that rabbit hole.
Yeah, I mean, like to me, you attack the timeline and you say, look, like our dude was there, but we're suggesting the girls weren't. Like to me, the biggest piece of evidence that is a mystery that I can't wait to hear some experts opine on it is the phone connecting back to the tower at 4:30 a.m. I want like what do you think about that? Like I'm curious. Like to me, it's a true mystery. Like why? Because we know AT&T was pinging every 15 minutes, you know, and to
I'm
me,
just not an expert in all that, so I don't know how it works.
I'm not.
Phones
either,
are weird.
man.
Like I can be driving and then all of a sudden I don't have service.
Me too.
And I go 5 feet to the left and all of a sudden I got 10 missed calls. So
same with me, you know, and I've got
or
AT&T,
even in
which is
Arizona,
habitually terrible coverage everywhere I go. I hate AT&T. I've been sucked in with them for like 15, 20 years. Like I'm always, and I always upgrade my phone. I'm like, I can't leave them. Like I want to leave them because they have no coverage anywhere. Because I live kind of rural. Yeah, T-Mobile, I hear is way better than AT&T. But I digress.
And even the weather, you know, I've been outside kind of doing yard work and my phone is exposed to the heat. And then all of a sudden I can't, you know, I'm not receiving calls or my phone's trying to shut down. When I go inside, it cools down and then here comes the phone calls.
Yeah, I don't like that. That thing's going to be an issue. Like that's the one thing they can get in. Like it's weird. It's weird. Like, you know, because it's like if it's there for 11 hours and they're pinging every 15 minutes for it to not connect with the tower at one point in time when it was connecting up until when we know it wasn't, it's a bad fact for the state. And it definitely creates a kind of a strange issue for them to try to address as to why. Because it like I'm making the argument that phone left Ron Logan's property and then was brought back, and the killer wanted the girls to be found, so they turned the phone back on. So that's when it hits the tower and they're able to find the girls when they find the ping. So I don't know, like that one, that's a big issue for the state in my estimation. We'll see how it plays out. Purdue, no, I appreciate that question. I always love that question because I love being able to try to explain what defense attorneys really do. Because people, when you watch Discovery ID and Oxygen for your entire life, that's what you think about defense attorneys, that we're just bottom feeders because they make every cop. Like I'm currently doing this series about this cop named Ronaldo Guevara, who literally framed up 57 guys. 44 have been exonerated in Chicago in the Humboldt Park, which is a Hispanic area in Chicago. 57 guys on murder beefs that none of them committed. He was using his confidential informants to finger innocent guys just to get them off the streets. Dude, they're like, I mean, there are bad cops out there. You know?
Oh, yeah, I agree. I'm definitely not pro law enforcement or pro defense, pro prosecution.
It's like I'm just pro like the truth.
Yeah.
And it's like so hard. Like sometimes, a lot of times, the truth.
I think ego plays a big part in the argument as well. So
totally, like, you know, and what drives me nuts about prosecutors is like from the prosecution side is that if they know that they've made a mistake on a case that they find out after the fact, they just refuse, even if it's not their case that they tried 15 years later, and they're just dug in on their position. They're like, they never admit that they made a mistake. And it's
Have
like,
you heard of the Zion murders?
yeah, I have.
Where
Yeah.
the father was held as the prime suspect, never made it to trial, and then they had actual DNA evidence that they found a match to that was found
Yeah.
inside of the victim,
Yes.
and they still waited 3 years,
Yes.
you know,
Somebody just
instead of
brought up
freeing
the
him.
Zion
Yeah,
murders cases to me like in the last week. I had not heard of it.
I covered it last week. That's probably
Oh,
why.
you did? Maybe I watched your. I might have watched your
Yeah.
live.
I'm not seeing too many more questions. Let's go here. I think we got one from Farmer, and then I think we'll let you go.
Okay.
Uh,
Feel
I
without
f-
defense attorneys is about up there with without. Yeah, I mean it is, Farmer. I mean, like, because like the Bill of Rights that matter for us in the criminal justice system are the fourth, fifth, and sixth. You know, you got your first and second, which are obviously like all of our rights are exceptionally important. It's like the fabric of how we live. So, and again, like defense attorneys, if you think of, if you take anything away from this conversation, take this away, that it truly is defense attorneys are the only ones who defend the principles of the Constitution for us, the citizens. And it's like, you could be sitting there saying, well, I don't ever commit crimes. So I like, what do I care? Well, just imagine getting picked up for something that you didn't commit, but they like you for whatever reason. And like, I don't want to get into the AI rabbit hole and deep fakes and stuff like that.
yeah,
But if you guys don't think that that's coming, if you don't think
it's already
that
here.
it's here, man, and it's scary. And
That's
it's
why they
just,
need that
it's
nexus.
man, yeah, it's dude, it's a thing. It's a thing. So yeah, no, I agree. Can you
There's
ask him
one
why
for you.
he didn't uh why
We
he
kind of
so
talked about, I think, why they changed the charges. I think we kind of touched on that
yeah, we
at the
did.
beginning.
We did. Yeah, go back. Like because he initially, like when you see from a defense attorney's perspective, when you see the state coming with a felony murder charge, and I won't drag on with this, but if you see felony murder is where if you can prove that the offender committed a felony, a different felony, which in this case is kidnapping, which then resulted in death, you then can get that person, even if they weren't the person whose by hand caused the death, you can convict them as if they were the person who caused the death. All right. So that's felony murder. So that's originally what he was charged with. I think that the move in the timing of it by McClelland was just to say, just to kind of like bristle up, because that happened right when they're in the court for the right in front of the Supreme Court. That's McClelland saying we have faith in our case. Because like typically when I see a felony murder charge and that's it, as a defense attorney, I'm like, they got gaping holes. Like they can't prove the murder. Like that, you know what I mean? Like that's the first thing that it tells us as defense attorneys. They can't prove the murder. They think they can prove this other felony, but they can't prove the murder. So I think that was McClelland bristling up and saying, we got a good case. We like our case. We're gonna put the full boat there, and we're gonna make the full run at it. So I think that that's probably what it was, because it doesn't really affect anything either way. I mean, they're putting on the same evidence. I think it was just, but like from the perspective of a jury, it's like I was talking about, and I don't know if you follow that Reed thing at all. I'm like, if
Not too much.
if I'm Lally, yeah, you're good. I mean, you got like one toxic community is enough, bro.
Yeah, exactly.
Trust
Yeah.
me. Like, and I
That's
was like,
exactly
dude,
it.
I know. And I was like if I'm Lally in that case, it's like anybody who watched that case truly is like they couldn't prove the intent necessary for the second degree murder charge. And I think that when you give a jury this concept of like, okay, well, we think that she killed him on purpose. There was intent there, that she hit him purposefully. Okay, which is the second degree. But then
Now
you
you got to
also have
prove
the
it.
manslaughter, which means that there was no intent. You don't have to prove the intent element, that it confuses a jury. They're like, okay, well, which one? Like, you don't even know. Like, you're saying out of one side of your mouth that she committed murder, but you're also saying that she didn't, because she didn't intend to hit him. That she hit him by accident and just left the scene of the crime. You know what I mean? Like, I think it puts questions in the jury's mind sometimes when you have some of those lesser includeds, because like homicide is just, if there's a death that's not suicide and it's either manslaughter, second degree, first degree, those all fall under the umbrella of a homicide, right?
Mhm.
So, and including involuntary manslaughter. So you've got voluntary, involuntary, and then varying degrees of first and second degree murder, but they all fall under the umbrella of the homicide. So all right, man, this was awesome.
Yeah. Anything you want to leave on? Anything you want to
No,
plug? Your link to your podcast is in the description.
awesome.
Anything you got coming up?
Yeah, awesome. Yeah, I've got like, I'd love to get more ears. Like, we have been covering this Ronaldo Guevara case with like these. It's an incredible story that no one's heard of. It's crazy. I had the filmmaker who's making the documentary. I mean, 50 like, and these guys did 20 plus years, all of them, like on murder beefs that they didn't do. And like, so like, but this work that I've been doing with Bill Dorsch, where it is true victim advocacy, where we are trying to find additional Gacy victims. And there's so many like young, like, people that watch YouTube. Like, a lot of people don't know who the hell Gacy is. So it's like, I'm always trying to educate. But like, for family members that have been waiting 40 plus years, killer clown, 40 plus years to try to find out where their missing loved one is, it's worth it to us, because if we're right about where we think that these bodies are buried, and we can give those families closure, we think that we've done a good thing. So that's cool. You know, so that's something I'm proud of. That's a passion project for me. And just check out the pod. If you guys have never listened to my regular podcast, I was a podcaster long before I started doing YouTube. I really started doing the YouTube because I was trying to bring people to the podcast. I'm really proud of it. The Gacy thing's unbelievable. My dad had left me all his Gacy tapes with he's interviewing the monster. They're fascinating. It's my dad going back and forth, just battling Gacy, and the guy's a monster, man. It's like his, just devoid of any kind of empathy or remorse. It's chilling to hear, man.
You're a
and
psychopath.
It's like, totally, man. Just like beyond. Like, to me, he was the scariest of all. He was like a true apex predator, just a shark, just picking these kids off. But it's fascinating, and it's not a Gacy story. It's really, I focused on the victims because I knew nothing. I knew everything about Gacy because it's been part of my life. My dad defended him in 80, you know, but I knew nothing about any of the victims. So we really tried to focus on the victims and giving them a name and telling people about who these kids were. So we're really proud of that. And then we followed the investigation, how they got Gacy after 6 years. I talked to all the old cops who were all just great old Chicago cops. I got the lead prosecutor. He performed his entire closing argument. That's how I closed the thing down. My dad did his own. It's different. It's like, if you love podcasts, and it's a super deep dive. So we're really proud of it. So check that out. That QR code will bring you right to it. And I appreciate you having me on, brother.
No, thanks for joining me. I really appreciate it. I think we covered a lot today. I think it was helpful to me as well.
Yeah,
answered a lot of my questions.
And I love the questions. I love the conversation. I mean, it's why we do what we do, you know. Like, nobody needs to be at war with this stuff. We can always just have civil discussions, and just, we're allowed to disagree about things. Yes, we're all grown-ups here. So, and I appreciate the chat. Thanks for hanging with us, guys. I had a great time.
All right, Bob. You have a great rest of your day.
All right, you too, Sleuth.
Take care. Bye.
All right, bye.
All right, guys, that's going to do it for today's live stream, and I'll see you again real soon. Make sure you guys enjoy the rest of your day. Replay crew, let me know what you thought about today's broadcast. Drop me a comment. If you guys need to get a hold of me directly, you can reach me at sleuthintuition.com. If you're trying to find Bob Motta's podcast, The Defense Diaries, the link is in the description. I want to give a special shout out to Boston Christian, Cindy Lean, and Peggy O for sponsoring today's live stream, and all of you who help out with the Cash App. On that note, guys, peace out.